The prosecutor did tell the judge what we had agreed on, and then the judge repeated it back.
Okay. But you don't remember who the judge was?
No.
Do you remember who the prosecutor was?
No.
Okay. So jumping ahead now, at some point you attempted to get documents to help you at this hearing at the Minnesota courthouse, like more recently, correct?
Mm-hmm.
How did that go?
Rebecca, you have to say yes or no.
Yes.
Thank you, Mr. Mogen.
It didn't go well.
Could you elaborate?
They didn't provide, they said they didn't have any records. They said they themselves had nothing on file of it. And then they directed me to their website to look on there, and I didn't find anything on there.
Okay. Do you have any intellectual disability or delayed learning abilities?
No.
Okay. Because you're an AB student, correct?
Yep. Yes.
Did you do some sort of questionnaire for the court when you were at the sentencing for the DWI back in the early 2000s?
Objection to the form of the question.
I don't.
Just wait 1 second. Can you repeat the question?
Did you do some sort of plea questionnaire at the sentencing for your DWI in the early 2000s?
And what was your objection?
At the sentencing would imply that it may have been done with the judge
And
as
or the
opposed to before.
I mean, there's nothing wrong with the question. If she has a response like that, she can make it. I think he's trying to testify for her.
Then the question's vague.
I'm going to overrule that. If you recall what happened at the sentencing, you may answer.
I don't know.
You don't know if you ever did a plea questionnaire.
I don't know if I did a plea questionnaire at the sentencing.
Okay, did you ever do one?
I don't know.
You don't know if you ever did. I'm gonna show you a document.
I need to look at it later.
That's okay. I'll send you a copy of it.
Yeah.
So I want to ask you specifically about pages 3 and 4 on that. Do you recognize those at all?
I recognize my writing. I can't say I actually recognize not that, I guess I don't remember the document from back then, but I do recognize my writing.
You recognize you're writing it, but you don't remember the document.
Right.
Okay. Okay. When you were 23, would you have signed something like this without reading it?
Objection calls for speculation.
It's not speculation, it's about yourself.
I will overrule it.
Yeah, I probably would have. I was nervous in the situation and probably just wanted to get it over with and move on with my life.
Okay. All right. I have no further questions on that.
Just a moment, Judge. I'm trying to get something up here.
Yeah, and then I'll just take the exhibits back.
I'm sorry, I didn't hear what Mr. Schmidt said.
He's taking the exhibits back.
Could I see the exhibits, please?
This one.
I don't need to see these. You can have these back.
You have any further questions?
No, non-direct
All right.
or cross.
Okay. Mr. Anderson, do you have additional redirect?
As soon as I review these,
That's fine. Take your time.
best I can. Ms. Almandinger, do you remember if you filled out these forms, did you fill them out in the presence of the judge or the prosecutor? If you remember.
I don't honestly remember.
Okay? And I note that, you can correct me, second page of one of these documents, which is entitled petition to plead guilty. Second page, it doesn't have any signature where the judge accepted that. You agree?
Yes.
Further questions?
Recross.
No. I do have documents that I'm obviously going to submit to the court now. I'm submitting a number of documents in a specific order. First is the document 26. That's the unsigned affidavit. The next is the document that both Attorney Anderson and I have been referring to with her, the plea colloquy from Minnesota. After that is the signed version of the affidavit, document 28. And the next two documents are transcripts, the transcript of the March 18th status conference and transcript of the March 24th status conference.
Are you offering them as exhibits and are you having them individually marked?
Yes, I'm showing them to Attorney Anderson before I walk over to the clerk for that.
No objection to those documents being marked?
Anything further?
No.
All right, you may step down. Thank you. No other witnesses
Or the witnesses?
and no witnesses?
No.
Okay. All right, well, the clerk is marking the documents. Mr. Anderson, argument.
If I could have the documents, I'd like to refer to them in my argument.
That's fine. We can wait.
I'm not going to rehash all of the testimony the court has already heard and it's fresh in the court's mind. The unsigned affidavit, I acknowledge was filed as an unsigned document along with the motion that I filed that triggered the need for this hearing today. The whole point of that affidavit was what I interpreted from Ms. Almandinger and put it into an affidavit format. And then before she signed it under oath, before me as a notary, she had additional information and certainly things that she struck from that affidavit. So I think the unsigned affidavit really carries little or no weight. The signed affidavit is what I think is the most important thing here. And I would ask the court to accept that affidavit as opposed to the unsigned. And that affidavit is Exhibit 3. The unsigned is Exhibit 1. What I think is important in the documents that have been submitted.
All right, time to break this one down. The final stretch of the motion hearing brought everything full circle, and while the fireworks never came, this part was all about the paper trail and legal cleanup. Rebecca Olmstedinger remained on the stand for a little longer, and at this point, you could tell the fatigue was starting to set in. She answered carefully, often with "I don't know" or "I don't remember," which again didn't come off as evasive, just honest. 20 years is a long time, and the fogginess around the details felt authentic. That said, the back and forth over the documents introduced some interesting wrinkles. We learned that when she tried recently to get records from the Minnesota courthouse, the results were, well, underwhelming. They told her they had no remaining records, directed her to a website, and she struck out there too. That sort of dead end doesn't help her much, especially when trying to reconstruct whether her 2005 plea was done by the book. It also doesn't help the court now, as Judge Mogen is left to assess everything with only partial documentation and decades-old memory. One key moment was the discussion around a plea questionnaire. Olmstedinger wasn't sure whether she ever filled one out, which might be a bit surprising, but again, nerves and the passage of time can cloud even significant events. When handed a copy that included her handwriting, she acknowledged it was hers, but didn't recall seeing the document itself. The clincher came when she admitted she likely signed it without reading because she just wanted to get the process over with. That's not a great look in hindsight, but it supports the defense's theme that her plea wasn't fully informed, even if not due to bad faith by the court. On the procedural side, things got technical. There was a bit of a dust-up over two versions of an affidavit, an unsigned one and a signed one with edits. The DA pressed her on whether she knew which one was filed, and Attorney Anderson acknowledged the earlier filing as his motion's trigger. Ultimately, Anderson argued that the unsigned version should carry little weight, while the signed affidavit, marked as Exhibit 3, should be considered the credible one. It was a clean and respectful handoff. Both attorneys had their say without drama, and Judge Mogen remained calm, giving everyone time to review the documents before arguments. And speaking of Judge Mogen, she once again did a solid job. She stayed neutral, kept the proceedings moving, and gave both sides space to build the record. When objections came in, she ruled with clarity. Even when the attorneys got into the weeds over exhibit numbers or speculative questions, she didn't let it derail things. The courtroom vibe stayed low-key, professional, and procedural. Definitely no fireworks, but that doesn't mean it wasn't meaningful. So, what we got here is a quietly complex hearing. It wasn't about who yelled loudest or who brought a surprise witness. It was about how a 20-year-old guilty plea, done without a lawyer, holds up under scrutiny today. And that question may come down to whether the court believes Rebecca Olmstedinger truly didn't understand her rights, or whether, despite her naivete, she still made a valid decision. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,